The New York Times wanted $150,000. Instead, they triggered an appeal that could reopen the entire fight. Sometimes winning is not enough. Sometimes you want payment. And sometimes that is the exact moment the other side decides to stop being quiet. Because everybody said this case was over. TMZ reported it like it was gospel. The rest of the major publications ran with it without blinking. They said Baldoni missed his window and that the deadline passed, that there was nothing to see here. Except somebody forgot to tell Kevin Fritz, because debt cases do not have 15-page oppositions filed in New York State Court. Yesterday, he filed paperwork that just detonated that narrative. And my personal favorite part? The New York Times caused it. After Liman dismissed Wayfarer's federal lawsuit against the Times back in June 2025, the Times could have taken the win and moved on like a normal institution would. But that was not enough. In September 2025, they filed a brand new lawsuit against Wayfarer in New York State Court under anti-SLAPP law. Anti-SLAPP laws exist to punish people who file frivolous lawsuits just to financially drain and silence someone. The Times looked Wayfarer in the face and said, "Your lawsuit against us was baseless, it was meritless, and now you owe us $150,000 in legal fees." Then, in January 2026, they filed for summary judgment, which is the legal equivalent of walking into court and saying, "This is so obvious, we do not even need a fight. Just hand us the check." They believed this was a victory lap. Turns out they may have strapped themselves to a hamster wheel. Yesterday's filing does two things at once. It opposes summary judgment, and it asks the court to stop everything, pause the case, and do not rule on a single thing. And buried in that filing is the sentence that changes the temperature completely. The Times acknowledges that its anti-SLAPP claim is entirely predicated on the federal court's dismissal of Wayfarer's claim, which Wayfarer intends to appeal to the United States Court of Appeals for the Second Circuit. They are officially appealing, and this time it is not rumor or online theory. This is no longer hypothetical. It is happening. And here is why that one sentence destabilizes the Times' entire state court case. The anti-SLAPP lawsuit has exactly one foundation. The Times has to prove Wayfarer's lawsuit against them was frivolous, and the only evidence they have is that Liman dismissed it. That is it. That is the whole argument. So if the Second Circuit looks at that dismissal and says Liman got that wrong, the anti-SLAPP case does not weaken. It disappears. There is no plan B and no backup argument. The filing says it plainly. If Wayfarer's claims against the Times are reinstated, the Times will have no basis whatsoever to claim those claims lacked a substantial basis in fact and law. The request evaporates right along with it. The Times went looking for a quiet payday and got a formal declaration that this fight is nowhere near finished. Now, I already know what all the major publications are going to call this appeal. They are going to call it a Hail Mary. They are going to say Wayfarer is desperate and grasping at straws. They are going to be wrong. The filing lays out two specific grounds for appeal, and both go directly at errors in Liman's June ruling that anyone who actually read that opinion could see. The first is that Liman incorrectly ruled that Wayfarer failed to allege the Times' smear campaign statement was made with actual malice. In defamation law, actual malice means you either knew what you were publishing was false or you did not care enough to find out. Wayfarer says they alleged that, and Liman said they did not. That is not a complicated legal debate. That is the Second Circuit opening the complaint and checking whether Liman read it correctly. The second ground is the one that had people who followed this case closely losing their minds the day that dismissal landed, for good reason. When you rule on a motion to dismiss, you accept the plaintiff's allegations as true. You do not weigh evidence. You do not pick a side. You assume the plaintiff is telling the truth and ask whether, if true, they have a legal claim worth hearing in court. Liman did not do that. He fast-forwarded to credibility before discovery even existed. Instead of accepting Wayfarer's version of events as true, he accepted Blake Lively's version as established fact. He took the cherry-picked evidence her team provided to the Times and treated it like settled reality while dismissing Wayfarer's well-pleaded allegations as if they were optional. The filing calls it exactly what it is, a presumption based on self-serving and cherry-picked evidence provided by Lively to the Times instead of accepting Wayfarer's allegations as true. That is textbook reversible error. And the Second Circuit is being asked to look at it directly. Now, let's talk about TMZ. When Liman's dismissal came down, TMZ ran a headline saying Wayfarer had missed their appeal deadline. Finished. Done. Clock ran out. Every mainstream outlet picked it up and repeated it without question. The narrative was locked in before anyone bothered to verify whether it was actually true. That is how myths are born. Not with facts, with speed. It was not true. Here is the short version. Blake Lively filed fee motions after the dismissal, and under federal procedural rules that pauses the appeal clock completely until the judge rules on them. Which means Harvey Levin, a licensed attorney, let his outlet tell the world the deadline passed when it had not even started. Whether that was a mistake or a choice, you can decide for yourself. Liman confirmed the window was still open in writing on October 31st, 2025. Friedman went on the record about it. And Harvey Levin eventually had to admit TMZ got it wrong. The window never closed. Here is the part that really needs to be said. The New York Times built this moment entirely by themselves. After Liman's dismissal, things went quiet. The trial on Lively's claims is not until May 18th. Wayfarer had no reason to announce appeal plans publicly. They could have filed when the time came with no press release, no statement, and no fanfare. But the Times filed the anti-SLAPP case. Then, they filed for summary judgment. And by doing that, they legally forced Wayfarer to respond in a public court document stating explicitly that they are appealing. The New York Times went and kicked the beehive, forgetting that bees do not negotiate after you mess with them. The argument for the stay is also hard to dismiss. The federal case was filed 9 months before this state case. If the Second Circuit reverses Liman and reinstates Wayfarer's claims against the Times, the anti-SLAPP case has no reason to exist. So why should a state court judge spend time and money ruling on a summary judgment motion that could be meaningless in a few months? The filing points out the obvious disaster of letting both cases run at the same time. This state court could rule against Wayfarer, while the Second Circuit simultaneously rules that Wayfarer properly stated their defamation claims against the Times all along. You cannot have both of those things be true, and courts do not like creating that kind of contradiction. Steve Sarowitz said back in August 2024 that he was prepared to be in litigation with the Reynolds camp for years. People heard that and thought it was a billionaire talking big. Reading yesterday's filing, it sounds more like someone who decided exactly how far he was willing to go and has been executing on that decision ever since. The case, the mainstream media declared dead, just walked into a New York State courtroom and told the Second Circuit it has something to say. And the New York Times handed them the microphone. If you are new here and you enjoy this kind of breakdown, hit subscribe. And drop your thoughts in the comments because I want to know if you think the Second Circuit is going to let this thing breathe or shut it down before it even gets started. And always remember,
that's my opinion!